Sacred property, cultural property, sacred space. What is that all about? Very fascinating subject. I have on the wall, if you come to my office, I look at it daily, a picture of the Temple Mount as it was reconstructed about 68 AD when it was destroyed by Rome. On the Temple Mount, I've taught in Jerusalem, and I remember one moment that's going to capture some of the issues in this particular case. I happened to be in the Mount of Olives, and I put my back against an olive tree that was purportedly over 2,000 years old, and therefore, in my theology, alive at the time that, from my perspective, my Savior atoned for the sins of the world on that mount. As I looked out, and as I tried to absorb through the bark of that tree and tried to get a capture in my own heart and mind that sacred, for me, a sacred moment, I look out to the Mount of the Temple Mount. I see some Islamic graves right in the front of the temple wall. I see what is called the Gate Beautiful, walled up by Islam hundreds and hundreds of years ago, because by tradition, Jewish tradition, the Messiah is going to be coming through that gate at some point in time, so they walled that gate up. It's the only gate that's walled up on Israel. I looked onto the Temple Mount, and on the Temple Mount they have the Dome of the Rock. The Dome of the Rock is over a rock that, according to Jewish traditions, is one of the holiest sites in the world, and Islam and Jews could not go up to that site for centuries. So on the other side of the wall, they have what is called the Western Wall. The Western Wall is where Jews, one of the holiest places for Jews, because they can't get to the Temple Mount, controlled by Islam. Islam has on that site the Dome of the Rock. The Dome of the Rock for them is one of the most holy sites, shrines in the world, is a shrine over a rock that the Jews believe is the most holy spot next to the Holy of Holies. It's actually part of the Holy of Holies, potentially. The rock where Abraham offered Isaac as sacrifice and established part of the covenant relationship between Israel and the world. So I see, as I sit there next to that tree, I see Christianity, I see Islam, I see Judaism, all identifying with the same sacred space. This particular presentation and paper deals with those issues of sacred space, cultural property. What are the moral, legal obligations of nations, of peoples, with regard to a space that's somehow made sacred by either religious beliefs or by construction, the Sistine Chapel, for example, Taj Mahal, the Kaaba in Saudi Arabia, the cube presented or built by tradition by Abraham and Ishmael. What creates sacred space, cultural property? Who owns cultural property? What are the obligations with regard to cultural property do each of us have? What about the military? We have a number of military people here. One of the papers, the very first paper, presented by Elizabeth Warner. We're excited to have her. She is both a lawyer and a museum director, and right now the director of the Museum of Sports. How appropriate, in the middle of the NCAA tournament. We have a director of the Museum of Sports here. And her biography is listed on the very last portion of this program. I don't want to go, I assume you all can read and go over this, but we have a remarkable opportunity to listen from her in her presentation about some of the specific obligations of the military during occupation and during attack, and both the responsibilities of the military when they're attacking, the responsibility of the people within the community. Who's responsible in Iraq when the military goes in and there's things looted from the museum and sacred space is invaded, cultural property is attacked? How do you designate cultural property? Once it's designated, how is it respected by the laws of the nations, by local laws, and by moral obligations? Those are very difficult issues. I'm pretty excited about the presentation. I'd like to introduce Elizabeth Warner.
Law Review, to Dean Craig Dallin, to Ms. Dirksen, and to Ms. Clementi. I am going to present an analysis of the United States military's legal duty towards cultural property under the ratification of the 1954 Hague Convention. Just to give you a little bit of background, I started writing this paper after learning that the 1954 Hague Convention had been ratified. Many of the law review articles available at this time advocated ratification of the 1954 Hague Convention explicitly to prevent another issue like the looting of the Iraqi National Museum from happening again. However, upon further research, I found many scholars and documents that suggested that the United States military might not have a legal responsibility under the 1954 Hague Convention to prevent third parties from looting cultural property. I was interested in this discrepancy in views and understanding of the United States military's responsibility under the 1954 Hague Convention, and that is something that I'm going to go through, the discrepancies in these views and what could potentially be the responsibility in this presentation. A quick clarification, I'm going to go through the United States legal responsibilities under the 1954 Hague Convention. This does not necessarily mean that some of the scholars I mentioned think this should be the legal responsibility. For an overview, I'm going to go over the 1954 Hague Convention, what exactly is cultural property, responsibility towards cultural property before armed conflict, during armed conflict, and during occupation. All of the articles that I discuss are going to be under the 1954 Hague Convention, unless I specify otherwise. Now, the 1954 Hague Convention for the protection of cultural property in the event of armed conflict was signed on April 14th, 1954. However, the Senate did not ratify this convention until March 13th, 2009. The convention includes a preamble, 40 articles, and regulations. The United States has also included 4 understandings and a declaration to clarify their legal understandings of the duties under this convention. This convention applies before and during armed conflict and during occupation. There are 2 protocols to this convention, neither of which the United States has ratified. The first and the second protocol requires prevention of illegal exportation of cultural property, restitution of any illegally exported cultural property, and enhanced protections for the cultural property. Now, what exactly is cultural property? Before reading the 1954 Hague Convention, I thought, a few degrees in art history, a master's degree, I might know what cultural property was. But there is a very specific definition under the 1954 Hague Convention, Article 1, that denotes what is cultural property. Under Article 1, it is movable or immovable property of great importance to the cultural heritage of every people. Now, this seems very vague, and in fact, it is. But this is the threshold for any protection under this entire convention. If you do not meet at least the basic cultural property definition, none of the other articles apply. It also includes buildings whose main and effective purpose is to preserve or exhibit the cultural property, and centers containing a large amount of cultural property. So as you can see, the basic definition, property of great importance to cultural heritage of every people, is pretty vague. Who exactly determines what this is? This has led to a discrepancy in views of what exactly is cultural property under the 1954 Hague Convention. For example, President Clinton's message to Congress in 1999, when he was suggesting ratification of this convention, stated that the definition is merely restricted to property of great importance only. However, in a letter to Congress by 15 cultural organizations, they stated that Article 1 of the Hague Convention offers a broad definition of cultural property. As you can see, one cause of the discrepancy of the misunderstanding of the United States' duties to protect cultural property is the difference in understanding of the basic threshold of what exactly is cultural property. All parties to the convention have responsibility towards cultural property before an armed conflict. I don't know if you can see this well. I can provide PowerPoint later. The future invader and the invaded under Article 9 or Article 7 have duties to instill respect for cultural property and provide instructions to ensure compliance with the 1954 Hague Convention before an armed conflict actually even happens. They must install people in their structure to ensure respect for cultural property and support civilians in safeguarding their cultural property. The future invaded have additional responsibilities. Under Article 3, they must prepare for the safekeeping of cultural property against the foreseeable effects of an armed conflict before the armed conflict happens. Moreover, under Article 4, subsection 5, the invader cannot evade their duties if the invaded did not comply with their Article 3 responsibilities to prepare for safekeeping of the cultural property. Under Article 6, the invaded can also mark their cultural property with an emblem that's described in Article 16. It's essentially a blue diamond square with two white triangles and a blue triangle above it. Article 17 dictates the use of this emblem. It's important to use the emblem correctly. If you mismark cultural property, as I will discuss later, it can actually, even if it doesn't rise exactly to cultural property, it can let it be harmed because it's considered a misuse of cultural property. All parties have a responsibility towards cultural property during an armed conflict. In this section, I'm going to go over the United States military's responsibility towards cultural property during an armed conflict, including an offensive military action, a potential defensive military action, and the responsibility of persons in the armed conflict zone towards cultural property during an armed conflict. The United States military has a responsibility towards cultural property during armed conflict. In an offensive military action, the United States has a duty not to harm cultural property. There are two exceptions to this duty, however, including the military necessity exception and the misuse of cultural property exception, which I alluded to earlier. In the defensive military action, the United States might have a duty to protect cultural property. There is a discrepancy in views, which I discussed on my introduction. The first view states that there is a duty to affirmatively protect cultural property from all persons, including third parties. However, in the second view, there is no duty to affirmatively protect cultural property from third parties. The United States appears to have followed the second view and does not believe that there is under 1954 Hague Convention, they have a duty to protect cultural property from third parties. In an offensive military action, the United States has a duty to not harm cultural property. Under Article 4, subsection 1, it requires the parties to respect cultural property by refraining from any act of hostility directed against such property. Under 1907 Hague Convention, Article 27, the United States has a duty not to harm religious, art, and historical buildings and monuments as far as possible. Now, I'm going to discuss the 1907 Hague Convention in this talk because the 1954 Hague Convention supplements the 1907 Hague Convention, which the United States signed in 1907 and ratified in 1909. The United States Military Handbook 27-10 also references the 1954 Hague Convention and states that the United States is not to attack cultural property. There are two primary exceptions that limit the duty to not to harm cultural property. The first exception to the duty not to harm cultural property is the military necessity exception, which allows an actor to proceed and harm cultural property without fault and provides flexibility to the military. Under the 1954 Hague Convention, Article 4, subsection 2, destruction of cultural property is permitted if military necessity imperatively requires such a waiver. And under the 1907 Hague Convention, Article 23, destruction is permitted if imperatively demanded by the necessities of war. The United States Military Operations Handbook 10-11 refers to the 1907 Hague Convention and notes the necessity is first, not a criminal defense, and second, determined upon the information available to the commanding officer at the time of the decision to harm the cultural property and cannot use information acquired subsequently or with the benefit of hindsight. There is a second exception to the duty not to harm cultural property, which is the misuse of cultural property exception. The duty to not harm cultural property is waived if the opposition misuses the cultural property. Misuse, as I stated earlier, includes using cultural property for military purposes or mismarking the cultural property. Under the 1907 Hague Convention, Article 27 waives the duty not to harm cultural property if the cultural property is being used at the time for military purposes. Under the 1954 Hague Convention, Article 4, subsection 1, parties must not use cultural property for purposes which are likely to expose it to harm. And under the Military Handbook 27-10, mismarking cultural property is a misuse, and the misuse of the cultural property will expose it to harm. There are discrepancies in views of defensive military action. The basic issue is this: does the United States have a duty to protect other nations' cultural property from third parties after ratifying the 1954 Hague Convention? The article at issue is the 1954 Hague Convention, Article 4, subsection 3, which states that contracting parties will undertake to prohibit, prevent, and if necessary, put a stop to any form of theft, pillage, or misappropriation of, and any acts of vandalism directed against the cultural property. Now, the first view argues that the United States has a duty to protect cultural property from all parties, including third parties. Advocates of this view point to the text of Article 4, subsection 3, which the term states any, which suggests that cultural property is covered by the 1954 Hague Convention is protected from anybody, including civilians. However, there is a second view that argues that the United States does not have a duty to protect cultural property from third parties. Corwin Wegner, president of the United States Committee of the Blue Shield, has noted that Article 4, subsection 3, was typically interpreted to prevent looting by their own military forces and not third parties. Dr. Petty Gerstenblit has also noted that one argument supporting this view is that all of the other 4 provisions of Article 4 only apply to state conduct, and another argument she proffered is that the law of war typically only applies to state conduct. Thus, as you can see, there is a discrepancy in the views of the United States' responsibility to protect cultural property during an armed conflict. It does appear, however, that the United States follows the second view and does not believe that they have a duty to affirmatively protect cultural property from third parties under the 1954 Hague Convention. Okay. The United States does not appear to believe that the 1954 Hague Convention requires the protection of cultural property from all parties, including third parties, as is seen by the United States' interpretation of the 1954 Hague Convention and the United States' belief that the United States has already complied with the 1954 Hague Convention. First, the United States' interpretation of the 1954 Hague Convention and public statements by United States officials indicates that the United States probably does not believe that they have a duty to affirmatively protect cultural property from third parties. John Bellinger, the legal advisor to the State Department, has stated that the 1954 Hague Convention prohibits direct attacks upon cultural property, theft and pillage of cultural property, and reprisals against cultural property. Charles Allen, the Deputy General Counsel of International Affairs, noted that the 1954 Hague Convention prohibits use of cultural property in armed conflicts for purposes likely to expose it to damage or destruction or damage. And the United States Military Operations Handbook 10-11 states that the 1954 Hague Convention prohibits targeting cultural property. However, these statements do not suggest the United States believes that they have an affirmative obligation to protect cultural property from third parties. It's merely restating the duty not to harm. Second, the United States' belief that the United States already complies with the 1954 Hague Convention indicates that the United States probably does not believe they have a duty to affirmatively protect cultural property from third parties under the 1954 Hague Convention. For example, in 1999, President Clinton, in his message to Congress suggesting that the Congress should ratify the convention, stated that the United States military policy and conduct of operations are entirely consistent with the convention's provisions. And in 2003, the Iraqi National Museum was looted. However, in 2008, General Brigadier Johnson advocated ratification of the 1954 Hague Convention to the Senate Foreign Relations Committee, noting that the Hague Convention does not in any way limit the flexibility of our military. Moreover, Bellinger, the legal advisor to the State Department, also advised ratification of the convention, noting that United States practice is entirely consistent with this convention. As United States officials stated before and after the looting of the Iraqi National Museum that the United States complied with the 1954 Hague Convention, they probably do not believe that the United States military has a duty to affirmatively protect cultural property from third parties under the 1954 Hague Convention. Persons in the armed conflict zone also have a responsibility towards cultural property. Under the 1954 Hague Convention, Article 4, subsection 1, it requires that persons not use cultural property for purposes that would subject the cultural property to harm in armed conflict zones. All parties also have responsibilities towards cultural property during occupation. In this section, I will go over what is occupation, what are the United States' responsibilities towards cultural property during occupation, and what are the persons in the armed conflict zones' responsibility towards cultural property during occupation. First of all, what exactly is occupation? Under the 1907 Hague Convention, Article 42, an area is occupied when it is under the authority of the invading forces. And in the United States Military Handbook 27-10, occupation is invasion plus taking possession of the enemy territory for the purpose of holding it. The handbook also has a list of factors that aid in determining whether occupation has occurred. The 1954 Hague Convention does not define occupation. Occupation can be difficult to determine. Dick Jackson, a retired judge advocate in the Army, wrote that there is still considerable controversy about when United States forces established effective control over the area of Baghdad near the museum. The United States has a responsibility towards cultural property during occupation. The 1954 Hague Convention, Article 5, entitled Occupation, is the main article in the Hague Convention that addresses occupation. Under Article 5, the United States has a duty to support competent national authorities of occupied countries in safeguarding and preserving cultural property as far as possible and take necessary measures of preservation as far as possible if the competent national authorities cannot. However, there is a discrepancy in the views of the United States' duty towards cultural property during occupation. Under the first view, the United States has a duty to protect cultural property from third parties during occupation because they believe that Article 4, subsection 3, and Article 5 applies to occupation. Article 4, subsection 3 refers to stopping any theft and vandalism. Advocates of the first view that I discussed earlier believe that Article 4, subsection 3 requires protection from all parties, including third-party civilians. And advocates of this position argue that Article 4, subsection 3 does not contain any limiting language that would restrict it only to armed conflicts and not occupation. And that's how they believe that their view of Article 4, subsection 3 also applies to occupation. However, of course, there is another argument. And this argument is that there is no duty to protect cultural property from third parties during occupation. The United States only has an obligation to comply with Article 5 during occupation and not Article 4, subsection 3. Dick Jackson, retired judge advocate of the Army, noted that Article 4, subsection 3 only applied during military operations, and Article 5 only applied during occupation. Advocates of this position argue that Article 5 is entitled Occupation, which indicates that Article 5 is the controlling article during occupation. Article 4, subsection 3 is also not under Article 5, which is entitled Occupation, and they feel the two do not go together. As you can see, there are discrepancies in understanding of the United States' legal responsibility during occupation towards cultural property. Persons in the armed conflict zone also have a responsibility towards cultural property during occupation. Under Article 5, subsection 1, since the occupier has a duty to support the occupied and safeguard and preserve its cultural property, the occupied have the primary duty to safeguard and preserve that cultural property. Now, my final thoughts. As you can see, there are discrepancies in the views of the breadth of the definition of cultural property and the duty to protect cultural property from third parties during armed conflict and during occupation. This discrepancy will probably cause difficulties in the future. While it seems that the military and the cultural property specialist mostly believe that the United States does not have a legal responsibility under the 1954 Hague Convention to protect cultural property from third parties, there is a contingent of people who believe that they do have this duty. Moreover, the cultural property specialist, while recognizing that there is not a legal responsibility under the 1954 Hague Convention, believes that the United States military should protect the cultural property. These different views will cause difficulties when the United States military action or inaction involving cultural property is in the media spotlight again. Thank you.
Thank you very much. This is going to be fun because this is the general and the abstract. Now we get to the particular. Nowhere in the world, I think, is there more controversy and conflict over sacred property and cultural property than in Israel. The next presentation deals with that very issue in specific. A number of questions with regard to where there's competing cultural identity interests in particular cultural property. In this particular case, the question of the graves of Abraham and Isaac and Jacob and Sarah and Rebecca and Leah. Who owns that property? Whose responsibility is it to maintain it? What responsibilities do we have with regard to that responsibility? It is now currently in, it's an occupied territory of Israel, controlled by the Palestinians, and has been designated as a national historical site by Israel. Interesting. The next paper deals with the conflicts between competing claims. Different religious beliefs involving the same people, the same property, the same issues, as I talked about in the temple itself. You've got the Dome of the Rock, that's the third holiest site in Islam. You have the temple site, which is the holiest site of Israel. And you have Christian claims. In this particular claim, where you have national identity issues associated with cultural property, how is it resolved? Wow, tough issue, interesting problem. And we have presenting this paper is Professor Kimberly Alderman. Her biography is in the very top level of your program. She is a clinical assistant professor at Wisconsin and drug her away from the NCAA tournament. Her Wisconsin fighting in that particular tournament. She is both a lawyer and a teacher, and she's in one of the classes she teaches, which would be a fascinating. I'd like to come and take it. Cultural property law seminar course dealing with these issues. What are the moral and ethical and legal? We've talked about the legal, the treaties, and everything else. What are the moral obligations, and whose claims trump the other person's claims? What if we have a complex of religious identities associated with the same property? How do you respect it? How do you designate it? Is designation itself a misappropriation, a hijacking? Professor Alderman.
Good morning. My name is Kimberly Alderman. So thank you all for having me and for being here. Ms. Varner's talk was perfect to precede my own because I'll be talking about the 1954 Hague Convention for the protection of cultural property in the event of armed conflict in the context of occupation, arguing that if construed broadly, that it protects against in situ appropriation of cultural sites. I will look at this issue through the lens of the 2010 designation of 2 West Bank mosques in Palestine as Israeli heritage sites. I will take approximately 5 minutes first to give background and set the scene. So Ms. Varner covered the definition of cultural property from the 1954 Hague Convention, which was in fact the first use of the term cultural property. Since that time, cultural property has come to be known as ancient and historical objects and sites with a subjective cultural value. Cultural property ranges from movable objects, such as this 14th century Aztec mask, to sites, immovable sites, such as the pyramids at Giza, the largest of which dates to the 26th century BC, to more recently, intangible cultural property. The Peking Opera, for instance, was granted protected intangible cultural property status by UNESCO in 2010. And cultural property law is the body of laws pertaining to the disposition, trade, and protection of cultural property. Some of those laws are aimed at regulating cultural property, while others may pertain to it only incidentally. My research focuses on the evolution of the cultural property protection model, and I suggest that it is moving away from a property framework and toward a human rights framework. I suggest that in the 19th century, cultural property was dominated by notions of private property, and the focus shifted to public property in the 20th century, and that the next stage in this evolution is human rights, which is the focus for the 21st century. When cultural property is viewed as a human right, then it implicates the issue of this symposium, ethics in war, terrorism, and military law. I argue that these three indicators demonstrate that the cultural property protection model is evolving away from a property framework and toward a human rights framework. The first is the increasing protection granted to intangible cultural property in recent years. The second is the tenor of repatriation efforts, in that it is no longer necessary to have a cognizable legal claim in order to demand the return of cultural materials. The third, and the one that's relevant to our discussion today, is international law. At common law, cultural property was viewed the same as any other property. Movable objects were personal property, and archaeological sites were real property. Crimes against cultural property, such as taking too much as a spoil of war, were viewed as just that, property crimes. Moving into the 20th century, national governments scrambled to lay claim to ancient and historical objects and sites originating within their borders, reflecting the public property model that I mentioned. In the mid-20th century, the international community started viewing cultural property as a global value. In 1954, both the European Cultural Convention and the Hague Convention for the Protection of Cultural Heritage in the Event of Armed Conflict recognized that losing cultural heritage damages the collective culture of the world. In the past 10 years, international agreements have deemed cultural authenticity as a human right, expanded on what it means to have a human right to participate fully in a cultural life, and the 2007 UN Declaration on the Rights of Indigenous Peoples stated that Indigenous peoples should control their own cultural resources. This contradicts how national governments have traditionally controlled cultural resources of Indigenous peoples within their borders. So over the last 100 years, we've seen a shift in focus in international law pertaining to cultural property, from a focus on individual ownership to a focus on government ownership, to a recognition of the global value of cultural heritage, to the idea that there is a human right to cultural heritage that exists separately from ownership concerns, but sometimes implicates them. It is this shift that, in part, explains the immediate and severe response from the international community when Israel named 2 mosques in the occupied Palestinian territory as state national heritage sites in February of 2010. Israel made a last-minute decision to include the Ibrahimi Mosque in Hebron, pictured here, and also called the Cave of Machpelah, or the Cave of the Patriarchs, and Rachel's Tomb in Bethlehem, also called the Bilal bin Rabah Mosque, as designated Israeli cultural heritage sites. Judaism and Islam agree that the biblical and Quranic patriarchs Abraham, Isaac, and Jacob are entombed in the cave complex beneath the Ibrahimi Mosque, as well as matriarchs Sarah, Rebecca, and Leah. Since the 7th century, the site has been used as a mosque in large part exclusively. Israel seized the site during the 1967 Arab-Israeli War, and it lay on disputed ground, occupied by Israeli military forces, but home to Palestinians. There has been some protest that Israel is not occupying the West Bank, but the United Nations and international community have deemed it an occupation, and it's going to be treated as such for the purpose of this discussion. This is the interior this is Isaac's tomb. And this is Rachel's tomb in Bethlehem. Many Palestinians viewed Israel's designation of the mosques as national heritage sites as an attempt to hijack Muslim holy sites, going beyond mere military occupation and making a permanent claim to an area of great importance to the Muslims. The designation exacerbated tensions and led to renewed conflict as riots followed the February 2010 announcement. The international response was immediate. Within days of Israel's announcement, UNESCO issued a statement saying that it was concerned. The EU Foreign Policy Director criticized the designation, and Hillary Clinton followed suit in front of the U.S. Congressional Committee. Israel responded that the designation was administratively necessary to maintain the sites. In October, UNESCO's executive board issued a formal decision regarding the designation, stating, "The board voted 44-1 to reaffirm that the two sites are an integral part of the occupied Palestinian territories and that any unilateral action by Israel is to be considered a violation of international law." The board considered the issues with another site at the same time, called the Mughrabi Ascent Site, and instructed Israel that any physical damage to the site would be a violation of the 1954 Hague Convention. This is significant because even though Palestine is not a party to the convention because it is not a United Nations member state and lacks general international recognition as an independent country, UNESCO's executive board considers the 1954 Hague Convention applicable to Israel's occupation of Palestine because Israel is a party. But despite all of the international consternation that the designation generated, only the Palestinian Center for Human Rights argued that the designation violated the 1954 Hague Convention. PCHR pointed specifically to Articles 1, 2, and 9 of the Convention. The Ibrahimi and Bilal bin Rabah mosques qualify as cultural property under Article 1 because they are immovable religious monuments and archaeological sites of great cultural importance. This application is consistent with Israel's stated reasons for wanting to name the monuments as national heritage sites. Article 2 provides for the safeguarding and respect of qualifying cultural property. And Article 9 protects designated cultural property from any act of hostility directed against it. PCHR did not, however, cite to Article 4, which provides a potential basis for objection to the designation. This article, titled Respect for Cultural Property, describes what constitutes respect in the context of the 1954 Convention. It requires parties to prohibit, prevent, and if necessary, put a stop to any form of theft, pillage, or misappropriation of cultural property. Now, the 1954 Hague Convention is, for the most part, focused on physical preservation of culturally significant sites. The designation of the historic West Bank mosques as Israeli national heritage sites does not work against physical preservation. In fact, Israel has allotted a significant amount of money towards renovation of the sites, which are among 100 towards which Israel has pledged to invest $107 million toward renovation and preservation. Israel has stated that their heritage plan will increase access to the sites as well, because 2 hiking paths will connect the sites, one historical and one centered on the Israeli experience. Accordingly, both the Ibrahimi and the Bilal bin Rabah mosques will become part of a physical circuit of cultural sites significant to Israel. The preamble to the 1954 Hague Convention explains, damage to cultural property belonging to any people means damage to the cultural heritage of all mankind, since each people makes its contribution to the culture of the world. This constitutes a recognition that there is an inherent value to cultural sites that goes beyond mere property-based economic value. The only way the Convention can protect against a loss of that inherent value by way of in situ appropriations of cultural sites is via Article 4, which protects against misappropriations. Israel cites to the book of Genesis, which states that Abraham purchased the cave for 400 shekels in order to bury his wife Sarah there. Abraham is a shared feature of Judaism and Islam, however, so this doesn't necessarily justify one group's cultural interest in the site over the others. Even so, Muslims have been using the sites as mosques for over half a millennium. While the sites are significant to the religious doctrine of both groups, as to the Ibrahimi Mosque, only the Palestinians have recent history on their side. Their emotional tie to the site arises out of centuries of consistent and near-exclusive use of the site as a place of worship. Israel has denied allegations that Palestinian access to the sites would be limited as part of the heritage designations, but concerns articulated by Hanan Ashral of the PLO's Executive Committee and Israeli left leader Haim Oran appear justified. In 2005, Israel decided to extend the separation barrier to include Rachel's tomb in the Israeli side of the West Bank, effectively annexing the site. Further, PCHR has reported a recent pattern of restricted access to the Ibrahimi Mosque. They allege that in the month following the designation, Israeli Defense Forces prevented the Muslim call to prayer in the mosque on 58 occasions and denied access altogether for 3 days. While reliable figures and data are hard to come by, the allegations indicate a disturbing pattern of conduct that forms the basis for Palestinian concerns about access. By laying a national claim to the sites, in particular the Ibrahimi Mosque, the Palestinians' cultural interest in the property is diminished, constituting an in situ appropriation of the site and potentially a misappropriation under Article 4 of the 1954 Hague Convention. In light of the purpose behind their convention, as reflected in the preamble, to preserve not just economic but also cultural values of ancient and historical sites, the designation is arguably a violation of the convention. In all cases, unnecessarily interfering with an occupied people's relationship with a cultural site when that site is otherwise under no specific and articulable danger of damage or destruction undermines the purpose behind the 1954 Hague Convention and should constitute a violation of it. Thank you all for your time and attention. I can be contacted via my website, culturalpropertylaw.net, and I welcome your comments or questions today or by email.
The general and the particular. Very interesting. If I understand the argument, let me ask the beginning question, and then we'll open the argument up. On the one hand, from Professor Werner, we have an occupying country has an affirmative obligation to protect the cultural sites within its occupied land. On the other hand, arguably, by exercising an effort to protect, take an affirmative action to protect by designated as a natural site, they violated the same convention. Am I understanding that right? It's a complex issue, isn't it? Whose site is it? Who's it belong to? Let me ask a related question. By building a mosque over the most holy site of Israel and keeping Israel off that particular property, is that misappropriating the identity of Israel? That's the issues, I think, some of the questions. Cultural property, fascinating ethical, legal issues. We have an argument that the same convention requires exactly the opposite response. Designation, non-designation, because of the competing cultural interests. I think this is one of the most perplexing and interesting issues throughout the world. How do we identify, how do we preserve, how do we keep cultural sites with integrity, and also how do we respect competing interests? We have a few minutes for questions, and do you want to have both of you come up and sit at the table so we can answer questions? It may be easier. Just stand up here so you can use the mic to answer questions. Any particular questions of people? Professor Kelly.
Well, those are both fantastic presentations. I couldn't help but thinking as I was listening to both of you. I'm one of the international law guys about the Law of the Sea Convention from the 1980s, and the argument was made during the negotiations from the ambassador from Malta that the oceans and the ocean's resources are the common heritage of mankind. And the idea was that there are some things in this world that have risen beyond possession by their people to include possession by everyone because of their relative importance. And the oceans are one of those. Could the cultural property schemes that you talked about rise to that level because of the significance of what we're talking about, instead of just belonging to one people or other people? Could the significance of these things catapult them into that realm of common heritage of mankind?
May I? it's an interesting question, and I think that that kind of sentimentality is reflected in the text and spirit of the international conventions and agreements that we saw coming out in the mid-20th century. And I think that after that, we started to see some of the challenges of globalization and some indigenous groups getting kind of washed out and disadvantaged in the wake of globalization. And that's why I think it's kind of shifted away from the global value kind of concept, is because the global value concept ends up disadvantaging descendants of creator cultures or indigenous creator groups. And you also saw the national governments start to kind of take ownership of things that when we stopped and said, wait a minute, did the national government create these objects, or did the people, or did a certain segment of the people, or did people maybe over two different nations, a group that spans two different nations, did they create the objects? So I think of it as a global value myself, but I also understand that thinking of it as such doesn't necessarily provide the protection to indigenous groups or creator cultures that maybe we'd like to see.
One thing I was thinking is in the Hague Convention, there's also an entire chapter for specially protected pieces that all the high contracting parties have to agree is specially protected. And these are essentially removing them from the realm of touching them. It's much more protected, and I think that might address some of your concerns. But another thing that I found interesting was I wrote a paper on the Titanic, which, as you know, has been going through the court system, and it is in international waters. However, even though it is in international waters, it seems that each one of the countries who had an interest in the Titanic were really just duking it out because they knew it was so special. They all wanted part of the Titanic. So that might, by having no one have a right to it, it just might start a race to everybody trying to grab what they can. I don't know if that addresses that.
Other questions? Yes?
Before the invasion of Iraq and the occupation, the United States stated publicly that they would take action to protect Iraqi cultural sites. Could this be seen as imposing an affirmative duty on the United States to stop that looting?
In regard to that, they did state that they would take active, they would protect cultural property. But as you can see in my argument, what exactly is required to protect cultural property is really a complex argument, because they did have a no-strike list in which they listed several pieces of cultural property, several monuments, several locations, which they had an elevated duty they imposed upon themselves not to damage. However, I think they're looking at state conduct, and they do have lists of things that they need to consider before taking action against cultural property. But I think that's different in their argument and in the legal analysis from affirmatively going in and protecting cultural property from third parties who are not the military. But there are several people who have argued that as reports came out, how they sent people in to protect oil or go in and take over and change out the judiciary, which I have in my paper, that they should, in the next conflict, do the same thing with cultural property and send people ahead to protect it in response to third parties.
Other questions? Yes.
Isn't one of the issues or part of the problem whether a contracting party admits there's an occupation or how that contracting party defines occupation? And it seems like that's the agreement process that you're talking about.
Yeah, and Elizabeth and I talked a little bit about this yesterday because the 1954 Hague Convention doesn't really define occupation, and we were saying, well, is occupation, and they have, Article 5 that pertains specifically to occupation, but is occupation something separate than armed conflict, or is it a subcategory of armed conflict? Because as I see it, it's a subcategory of armed conflict, even though, in the international scheme, occupation doesn't mean boots on the ground. It doesn't necessarily mean armed conflict. It means effective control over a region. So, international law is fluid, and I think of it as like a little bit more organic than other forms of the law. But if Israel has stated pretty clearly that they don't feel that what they're doing is occupation, and so under their viewpoint, it wouldn't apply. They have a claim to the land in their viewpoint, so that's absolutely an issue. I think that, but Israel has also stated that without conceding the point on occupation, they've also stated that they are making all attempts to abide by the 1954 Hague Convention in the process of this dispute.
Yes.
To your arguments about the Hague Convention, does the Hague Convention 1954 apply to older situations such as the elder marbles and the permanent degrees?
Well, you seem to.
I don't think they apply retroactively. I think they only go forward, and then many locations have stated understandings and declarations that also limit their duty going forward.
I would say that I don't think that from a legal statutory analysis type of a framework they would apply retroactively, but the way that I view international law, and I'm not an expert, but the way that I view it is that these agreements and their conventions, they tend to reflect international norms, and the more of these things that we have reflecting certain international norms that are developing, the more likely it is. I mean, you have so many people in Britain thinking that the marbles should get sent back, and the more international pressure gets laid on Britain, I mean, if that's the direction it goes, then the more likely it is, practically speaking, that they will get sent back.
Other questions? Appreciate it. We're actually on time. We're excusing you for lunch, and you can discuss the issues amongst yourself or have some questions afterwards come up, and we'll be back in 1 hour and continue the presentation.